The first stage in a confiscation hearing is to determine whether a defendant has what is known as a criminal lifestyle. If a defendant has a criminal lifestyle, the court is obliged to make certain assumptions, unless a defendant establishes that it would be incorrect to do so, or the court decides that it would be unjust to do so. Injustice in these circumstances has been defined very narrowly. We welcome views on whether these statutory assumptions lead to the making of realistic and enforceable confiscation orders. There have been over 350 appellate decisions on confiscation law. One of the things we are considering is whether the current statutory framework is sufficiently clear and precise. Does the statutory language reflect the process adopted by the court? Having calculated the defendant's benefit from crime, the burden of proof shifts to the defendant. If the defendant satisfies the court that their assets are insufficient to repay the entirety of the benefit, then the court may make the confiscation order in the lower amount. If the defendant fails to do so, the court may find that the defendant has hidden their assets. Currently, over £432 million worth of outstanding confiscation debt is attributable to hidden assets. We welcome views on whether the current hidden assets regime leads to the making of enforceable and realistic confiscation orders. A defendant cannot escape a confiscation order by giving away their proceeds of crime. Criminal assets that are given to others are treated as tainted gifts and are taken into consideration in the order. What impact does this have on the making of realistic and enforceable orders? Tainted gifts will ultimately be held by third parties, whether a spouse, a family member, or otherwise. We would welcome views on how well the current law relating to determination of third-party interests works in practice. If you have any views on this topic or any of the topics in these videos, you can contact the team via our email address, confiscation1@lawcommission.gov.uk.